Um, I am looking at 3 cases. What? I can do it by myself. See that focus and concentration?
We were in a conference with Betty.
That's all right. I was talking to myself and didn't know it.
Judge, apparently Mr. Strolla has something he wants to bring up.
Our concern, Judge, is originally we weren't going to object to it. We looked at some research briefly. There have been instances where when jurors do their own quote-unquote experiments, that those verdicts can get overturned. My other concern is that Bendy has left the premises.
Who has?
The doll, they call it Bendy.
Oh.
Bendy, appropriately named, has left the courtroom. Had they asked for it to go back originally, and our concern is, and I'm not saying the state moved anything, but my concern would be if they're going to give greater weight to the dowels that were in a demonstrative aid that's not in evidence. That's my objection. I don't think I'd object to them having the Bendy doll without, or having the dowels removed, because at that point, if they're just trying to look at the body itself, that's fine. If they're trying to see where the state had the dowel rods in it, then they have to rely on their own memory of that.
I don't think they need it for the body itself. They've got photographs of that.
No, I meant Bendy, meaning, I didn't mean the Mr. Davis's body, the body of the actual doll to use in their own viewing.
Yeah, but then the next thing you know, they're going to start sticking pencils in it, trying to recreate the dowels. So that won't work. Well, all right, then I won't tell you that I found 3 cases that said if you agreed to it, you can do it. And if it's error, it's harmless error, and I think 2 of them were death penalty cases.
Anticipating an issue, we've asked Dr. Simons to come over to make sure he's comfortable with the dowels in Bendy. The problem with sending Bendy back alone is the type of dowels that were used for Dr. Simons' purposes would still show the jurors where those holes were. So your point about a pencil might not work, but a pencil would work in one short wound. So the holes are there, and Dr. Simons is going to be here to establish on the record that that's what she tested. There's also a picture from the internet, from the testimony that shows exactly where they were. So Bendy didn't leave this building, but my point is...
What picture from the internet?
Well, there's pictures from the internet.
Well, they can't look at that.
No, Judge. What I'm saying is that Mr. Strolla, he mentioned a concern that Benny might have been not
Tampered with somehow.
Well,
yeah. I know, that's too strong a word.
Yes, sir. So we have Dr. Simons, who's almost here, she'll be here in about 5 minutes, to assuage that concern. But if he's going to object to the dowels with or without Dr. Simons, what I'm telling the court now, and I can bring the bendable form in, the holes will still be there.
Listen, I understand that. If he's objecting to any part of it, we're finished. It's not going back. And so all I need to know is that. If you are in agreement to it going back and you want to have somebody come and show it to you and you're satisfied that nobody's repositioned the dowels, okay. But if you have any objection at all to it going back, it's not going back.
Can I speak to Mr. Dunn?
Sure. Sure.
Okay. Judge, I have talked to Mr. Dunn and consulted with him. He knows what my concerns were. We don't want Dr. Simons touching it because they would almost be retestifying for it. Mr. Dunn has no objection to the doll going back with the dowels the way they are now.
Okay, well, where is Bendy?
Right here in the little room.
Well, let's bring Bendy on in.
Yes, sir.
And if Bendy needs some help,
No, Judge.
I'll have one of the bailiffs escort Bendy in. While we were on the break, Mr. Stroll, did you look at Bendy?
I did when I was in that conference, but then now I'm still waiting for him to...
Okay, well, we'll bring Bendy in, And then you can look at it, and so can Mr. Dunn, and kind of go at it from there. And let them look at Bendy. And while you're looking at it, I don't know what cases y'all found, but for the record, the cases that, and I didn't do this, the law clerk did, so I'm not going to take credit for it, found a Supreme Court of Florida case from 1984, White versus State. And that case held that this was a first-degree murder case. I believe the death penalty was part of that case, which it is, of course, not part of ours, but it shows the significance and severity of the case.
There's a second hole next to one of the holes.
That's why we have Dr. Simons come.
So in the White case, the prosecutor used a chart in which he checked off the aggravating and mitigating factors. There was an agreement with defense counsel that the chart would go back into the jury room. The defendant was convicted in that case and then appealed, and one of the grounds on appeal was that the chart should not have gone back and been submitted to the jury during their deliberations. And they cite Florida Rule Criminal Procedure 3.400, which would indicate demonstrative evidence does not go back to the jury. However, the Supreme Court of Florida held that the appellant, meaning the defendant in that case, cannot at trial create the very situation of which he now complains and expect this court to remand for resentencing on the issue. So basically they were saying because the defendant agreed, it was, to the extent it might have been an error, it was a harmless error. Additionally, whoops, I didn't cite that case, did I? 446 Southern 2nd, 1031. Another case, this is a 3rd District Court of Appeal case. It's Olston Health Services versus Cody, C-O-D-Y. Actually a civil case. I've got to find it, but I believe they sent some blow-up photographs back.
Judge, I can stop you right now.
Oh.
So you don't have to keep reading.
Good, thank you.
Sorry, Judge, I don't want you to have to waste any more. I apologize for interrupting the court. Because the dowels did get moved around and go back and forth, and I absolutely would not rely on Dr. Simons coming to almost retestify, Mr. Dunn would object. And
Okay, fine. So then, let's talk about the answer to the question. I can simply say, no, you can't. I could say, no, it was only a demonstrative exhibit, not an exhibit offered into evidence, and you can only consider what's been offered into evidence.
I think, sorry.
You like the latter?
Yes, sir.
Want me to write that down so I don't mess that up?
I think explaining it as a demonstrative aid would be appropriate, and to allow their memories. Maybe.
Okay. What I would propose to say is, when they come out, I'll say, obviously, I'll say, I've read your question, I'll repeat the question, and I'll say, regarding, and I'm going to use their terminology, the dummy with the sticks. We cannot send that back to you as it was a demonstrative exhibit, that is, an exhibit for demonstration purposes. It was not offered into evidence, therefore it cannot be sent back. You are only to consider items that were received into evidence, that were offered and received into evidence.
Well, Judge, my only concern about that last statement is they can consider the testimony about it. That's why I would suggest to say, please rely on your memories of the demonstration.
Okay, all right.
Because they can consider it as a demonstrative.
All right, well then let me try and,
Judge, I wouldn't go that far, because then it's almost putting emphasis on the state's direct examination. I don't want to create the portion of credibility of the state's direct. I think you leave it as is.
okay.
Say it wasn't an evidence, Judge.
All right, so let me back up. We cannot send that back to you as it was a demonstrative exhibit, that is, an exhibit for demonstration purposes. It was not offered into evidence, therefore it cannot be sent back.
Cannot be sent back. Thank you, Judge.
Period.
Yes, sir.
Did you say you're having them come back out, or you're sending them a note in, Judge?
No, I'm going to have them come out and answer the question for them.
Then if the state can remove, then you defer.
Absolutely. All right, so that answer is satisfactory.
Yes, sir. For the defense.
Mr. Dunn, is that satisfactory?
Sir.
I'm sorry.
Yes, sir.
Ms. Corey?
It is, Your Honor.
All right, bring the jurors in, please.
Jurors entering the courtroom.
Welcome back, ladies and gentlemen. Remember, you don't have to sit in the seats from before. We're past that, so you can all have a seat. We received your question. I've had a chance to discuss the matter with the attorneys. So regarding your question, can you get that dummy with the sticks? Regarding the dummy with the sticks, we cannot send that back to you as it was a demonstrative exhibit. That is, an exhibit for demonstration purposes. It was not offered into evidence, therefore it cannot be sent back. So that answers your question. I'll ask you to retire back to the jury room and continue deliberations. Thank you very much, ladies and gentlemen. All right, anything else from the state?
No, Your Honor. Thank you, sir.
From the defense?
No, sir, Your Honor.
Okay, we'll be in recess till we hear more. Thank y'all.
Thank you, Judge.
Mr. God.
Hmm?